Welcome everyone to the second session with Fragomen for an immigration webinar to the United States. I'm Ludivine Worksik, the Executive Director of FACCNE, and today's session is going to be dedicated to life sciences company. We want to thank Brian Doyle, Aaron Bloomberg, and Irma Diaz for sharing their expertise today.
Great. Thank you so much for the introduction. Good afternoon, everybody. My name is Aaron Blumberg. I'm one of the partners in the Fragomen Boston office, and I'm joined today with my two associate attorneys, Brian Doyle and Irma Diaz. Just for a brief bit of background, Fragomen is the largest and oldest immigration firm in the world. We handle immigration to literally every country in the world. Today we'll be focusing on US immigration, but if you ever have needs to send employees to other countries, you can always reach out to us. We're always happy to put you in touch with our colleagues, as we have about 55 offices all over the world. So we work together to coordinate transfers of employees from all different countries. So today the focus is on US immigration. And really to get started, I'm going to turn it over to Brian Doyle, and Brian's going to talk to you a little bit about the normal progression of individuals that are in the United States. And typically what we see is that a lot of companies hire individuals that are here as students, either on a student F1 visa or a student exchange visa called a J1. And so Brian's going to walk you through how the process works for a student after they graduate to move through the immigration process and gain sponsorship with an employer. Brian?
Great, thank you, Aaron. And thank you, Ludivine, for that introduction. We're happy to be here and be able to chat with everyone about this topic. And we have a lot of good information for you folks out there, so I hope it's very informative. But yes, Aaron, thank you for that introduction. I think a really good jumping off point for our discussion is to understand what the most common progression is for folks in the US in immigration status. Now, that's not to say that this is how everybody's immigration process will go. Everybody is different. Certainly there's different ways to be in the United States, employed in the United States in immigration status. And we're going to touch on all of that as we work through our discussion. But certainly folks that are in the United States, foreign nationals that are students in the United States, follow sort of the most common, the most typical progression from being a student in the US to working as a student in the US to holding what's called a non-immigrant, or basically a temporary work visa. That's sort of the alphanumeric visas people are familiar with, H-1B, O-1 visa types like that, and then transitioning into being a lawful permanent resident, or more commonly known as a green card holder. So I want to talk a little bit about how using student status and being here as a student can sort of be a springboard into sort of this process itself. I do think it's important to also understand, what student status is, how you obtain it, how you maintain it, and how you move from student status into a different employment-based status. And then, very often, whether or not it's a bachelor's degree, a master's degree, a PhD, again, it is most common that somebody working in the United States who is a foreign national will have obtained some level of a degree in the United States. And in doing so, you're holding F1 status. F1 status is available to folks from a very young age all the way through to basically through a PhD. But at the same time, we're going to talk about it more at the university level, bachelor's, master's, PhD programs. Being a full-time student, you are able to remain in the United States for the length of an academic program. So, usually you come to the United States, say, as a visitor, say you have ESTA. You come through the airport, the port of entry, you're given 90 days to be in the United States. There's a hard end date. With F1 status as a student, you're basically permitted to remain so long as you are maintaining a full-time class load and moving through your program. When going through your student program, very often you're going to be working with what's called a designated school official, a DSO, who's guiding you through. There's an online web-based platform called SEVIS that is used to sort of track by ICE, who oversees SEVIS, track that you are moving through that progression. But most importantly, when it comes to, moving on to a different immigration status, to gaining employment, to finding an employer, the real important aspect is what's called OPT, optional practical training. This most often happens after someone graduates from a university program. And what it is, it's a 1-year period to work in your field of study. It's an important aspect to not only sort of solidifying. Having gone to law school, I think the most instructive thing for me as a student was when I did internships or co-ops and getting that real world experience. And that's what OPT provides after graduation. So there's a 1-year period. And for a lot of folks, tuning in today to this webinar in life sciences and biotech, or really in any STEM field, there's also the opportunity to extend that 1-year period by an additional 2 years for 3 total years in OPT, basically working in F1 student status after graduation, gaining practical experience, and really creating relationships with an employer who then may want to certainly keep somebody on. And how is it that that person can remain in the United States working for that employer? Well, that's going to depend on a few things, but the most common way is going to be the H-1B program, which I will talk about in just a second. Before I do that, though, I do want to talk about sort of another sort of springboard visa type that folks often use to then transition to another employment-based visa type, and that's the J-1 exchange visitor. It's really important to understand that the J-1 is an exchange program. I think, Aaron, you often tell folks to look at it, this is a cultural exchange program. This is not an employment visa, right? But it does have the benefit of, for whether it's for interns, whether it's for foreign medical graduates, whether it's for research scholars, to have sort of this work aspect, this training aspect that is in conjunction with this cultural exchange. Much like F1's track through that same web platform, the SEVIS system, there are certain benefits for dependents, but the one thing that's very important to understand about the J-1 exchange visa, not all, in fact, most often folks do not have this requirement, but many who do hold the J-1 visa type do have a 2-year foreign residency requirement, right? So it's a cultural exchange program. The goal is that someone might be coming to the United States, that might be obtaining a skill set through the program that they're experiencing in the United States. And the goal is, maybe that they should be taking that skill set back to their home country as part of this exchange program. So there are skills lists depending on the country that you're from, depending on the type of program that you're doing and the type of skills obtained through your program. There may be a requirement that you return to your home country for a period of 2 years before you're eligible for certain visa types like the H-1B or like the permanent resident status in the United States. Now, that's not a requirement for transitioning to all visa types, and later in the discussion, Irma is going to talk about some of those options as well. But it is important to understand as part of this cultural exchange. There are waivers available, no objection from your home government. For medical students, there's the ability to work in sort of an underserved area. So there are ways around this, but also very important to understand before jumping into this type of exchange program.
Hey, Brian,
Sure.
before you get into H-1Bs, a common question or concern that I get from employers is, how can I test out an employee and see if there's somebody that I want to make that financial commitment and sponsor them? So could you just touch upon, for specifically F1 OPT, are there any obligations for the employer? Are there fees that they have to pay? Could you just explain to everyone, what it takes from an employer to actually hire someone on OPT?
Sure. So in the OPT context, it is a little more, and from both the employer and for the student perspective, it's a little more sort of an open market feel. In the H-1B context, there are very specific employer obligations. There's very specific requirements to pay what's called a prevailing or sort of a minimum wage or salary to that employee. In the OPT context, there are requirements for the employer, but not to that same extent. The requirements are basically ensuring that, number one, this student is working in the related field, that they are reviewed appropriately, that there's documentation the student needs to make sure that they are working with their supervisor on to ensure that they are following sort of the program that's required. But it is certainly less stringent in the F1 context for employers than it would be in other contexts, because an F1 student is not tied to their visa status is not tied to a specific employer in the same sense that it might be in what we call an employer-sponsored petition, like the H-1B, that has very clear and stringent requirements of the employer itself.
Thanks, Brian.
So talking about the H-1B, and again, this is sort of, for lack of better put, sort of the bread and butter for a lot of employers, because many of their, to transition from a student status into a different non-immigrant or temporary work visa status. H-1B category is very commonly used. It requires sort of two key elements of the employee. Number one, that the role they're working in requires a bachelor's degree in a specific field. I always say if the role itself requires a degree in computer science and basket weaving, that's not a specialty occupation that's going to meet the H-1B requirements. So the job itself has to require a bachelor's degree to perform the job duties, and the candidate itself has to have a degree related to those job requirements and the position itself. Now, the hiccup with the H-1B program is that there is a quota each year that limits how many of H-1B visas can be awarded to candidates that are sponsored by employers. So every March, employers can tell USCIS, the Immigration Service, I want to sponsor so-and-so for H-1B status in the United States. They're placed in a lottery each March. April 1st, USCIS notifies employers, these 10 employees have been selected, congratulations. The H-1B petition is then filed with USCIS to be substantively adjudicated. And then on October 1st, the new fiscal year each year, that student can work in H-1B status. So the good thing for students that are in STEM programs that is different from students that are not in STEM programs at the school level is that additional 2-year extension. The reason being, it essentially gives them 3 opportunities to go through the H-1B cap lottery and obtain H-1B status, where otherwise they might only have 1 opportunity while in the United States. Again, there are employer requirements, including paying, like I said, what's called a prevailing wage set by the Department of Labor, depending on the role and the geographic location where someone is located. There is also, a slew of financial obligations as well. But again, it is a very useful visa type to transition someone from student status into an employment-based status that's valid for up to 6 years in the United States. And again, we talk about, okay, someone is 3 years in F1 status to maybe get into H-1B or to get into another status. Well, H-1B status has, a maximum of 6 years. Well, how do we get someone to another status from there? Or how do we get them? What happens when 6 years are up? And we'll get to talking about that as we move through our discussion as well.
Brian, I just had a quick question for you on that quota. Employers often ask me, what can we do to increase our odds of being one of the 85,000 chosen? Is there anything that we can do? Is there anything that the employee can do to increase their chances of being selected? And this comes in light of the fact that this past year, I believe there was over 300,000 applications for the coveted 85,000 spots. So if you could just talk about that for a minute, I think that would be great.
Absolutely. So a few things, and the answer is sort of, but not really. I think is how I would answer that. So, there's, as you can see on my screen, there's 2 sort of pots here. One for those holding advanced degrees from US universities, very important, from US schools. If you get your master's degree in France or the UK or somewhere else, it doesn't put you eligible for that pot. So a lot of folks that have advanced degrees, masters or higher in the United States, sort of get 2 cracks at the lottery, just the way that the lottery is run. They can be placed in both. They could be run through both the 20,000 advanced degree pot lottery, so to speak, but also those holding, at least a bachelor's degree, the 65,000 sort of pot. At the same time, employers have to be really careful about double filing, I guess is how I would, or double submissions. And an employer is only able to submit one sort of application or one registration into the cap lottery each year. And sometimes people erroneously submit the same candidate twice. It can lead to a denial of H-1B H-1B petition, even if selected in the lottery. So there is a way, depending on the candidate's backgrounds, that they have the potential to have a better probability. But all in all, employers do have to be careful about trying to game the system, because the government does figure it out, and it can lead to negative consequences when trying to go through this process. The other key thing about H-1B status, before I hand it back to you, Aaron, is dual intent. So dual intent means that you can have the intent to either stay in the United States temporarily and maybe return to your home country once you're done working, but you can also have permanent resident intent. You can have the intent to pursue your green card and hold H-1B status. A lot of non-immigrant visa statuses, a lot of these temporary visa status in the United States require you to have temporary intent, require you to want to be, or require you to return to your home country at its conclusion. H-1B status is a different carve out. It allows you to have either intent without jeopardizing your status in the United States.
Thanks, Brian. And we had a good question that just popped up on the screen from the audience, asking if a J1 student can apply and be eligible for OPT.
So J1 students are typically going to be work authorized through their J1 program. And correct me if I'm wrong, there's no option for OPT through the J1 program. It is set to your program date. It is, once your program is over, you are either required to find another status to maybe transition into if you're eligible, or you're returning back to your home country.
Yeah, and for everyone on the webinar today, J1s are confusing just because there's so many different types. You have a J1 cardiologist, but you also have a J1 summer camp counselor or an au pair. But in terms of J1 students, they do get something called academic training, which, like Brian said, after they graduate, they are able to work pursuant to their J1 status. That's for the students, the J1 students. And just so everyone here knows, J1 students are not too common. Most students in the US are on F1 visas. The J1s are normally those students who are funded by like their home country government or their home country school. And the practical example to think of would be like an exchange visitor, like summer abroad or study abroad that you see here, but just going in reverse. Okay, so let me, I want to go back to the lottery because this really intrigues me, and I think it's really interesting. About how there's only 85,000 for over 300,000 applications, and I've had people, I've had clients that have had employees on OPT and STEM OPT who have entered and lost the lottery 3 times in a row. And so, Irma, would you mind talking a little bit about how do you advise clients that are in that situation where either their luck is not on their side and they're not able to win that lottery, or they're looking to hire someone that is outside the United States and wasn't here on OPT? Could you just talk about what are some of the other options outside of the H-1B that an employer may be able to look at?
Absolutely. Hello, everyone. My name is Irma Diaz, as my colleagues have shared with you. I think there are actually quite a few options for folks who did not get selected into the H-1B cap lottery, but do want to work in the United States and work for a particular company. If the person is abroad, you can explore the J1 option that Brian highlighted a few moments ago. And for the life sciences company, what I often see as a common way for folks to work here in the US is through the J1 Research Scholar. And they can actually be in that program up to 5 years, and they can actually work with an organization here in the United States. So that is a common option for someone who's abroad. Another option is the versatile O1 option. And the O1 option is reserved for individuals of extraordinary ability. And what that means is that you are someone at the very top of your field. And what is most common to life sciences organizations is an O1 in the sciences category. And as you can see listed here, it's also available for those in education, arts, business, and athletics. But the more common one for life sciences organizations are those that are actually working in a scientific field. And so the requirement for an O1 is, again, that you are at the top of your field. So you've risen to that field. You may be, for example, in the top 5%, and that you must demonstrate sustained national or international acclaim and recognition for those achievements. So essentially what they're looking for is someone that brings novel discovery, original contributions, and has had a major impact on their fields. For example, a researcher in bioinformatics, or someone that's working on a very novel area of cancer research. And they've been able to not only publish a number of research articles, but they've also have led to clinical trials, and other researchers are now benefiting from that individual's work. So in order to do that, the regulations outline specific criteria that have to be demonstrated in order to qualify for the O1. And so you would put together your petition for this individual and outline some criteria such as original contribution. They've been on a panel to judge the work of others. They have had their work reviewed by other experts in the field. So a number of different ways to show someone's extraordinary ability in that particular field. And so an O1 option is actually quite versatile in the sense that it provides candidates with the ability to remain in the United States for a 3-year period. And it also makes it easier if you're looking long-term to potentially remain in the United States on a more permanent basis. And I know we'll be able to touch upon that later on in the presentation. So an O1 is a great alternative to the H-1B for folks who are not able to enter that H-1B role, and allows, again, continued work authorization here in the US.
Irma, I know that the O1 is not an easy visa to get issued. It's really one of the more challenging, but I know that a lot of people disregard the O1 because they believe that you have to have won a Nobel Prize or something at that level to qualify. Is it really that difficult? Could you just talk about that for a minute?
Absolutely. I think that our firm, being the largest immigration firm out there, has a great footing into the O1 world. I know that folks are, as you said, hesitant to explore that option, but it actually is one that is has a really good success in terms of the statistics of it. USCIS actually ended their fiscal year and actually put out information that overall, although it appears to be difficult and there's actually additional scrutiny at the moment in terms of these case types, the overall percentage is close to 90% approval. And you do have to be very thoughtful in the way that you approach these petitions, and you want to also be aware of how USCIS is adjudicating these petitions. So for example, we're seeing a high increase in RFEs nationwide. So you'd want to be a little bit more aggressive in your initial filing. So although you only have to show 3 out of the 10 criterions to qualify for an O1, if you see someone that is meeting 4 or 5 or 6 of them, include all of them. make your best arguments up front, and illustrate how this person qualifies, because this process is also quite subjective. And so an officer can review it and say, you know what? Yeah, this is a very strong case. I see that they meet at least 3. We're going to approve it. In other instances where you feel that you have a very strong argument for one of the criterions, and the officer disagrees, you want to have additional ones that are demonstrated in the petition to increase your chances of success. So I think when partnering with a immigration counsel, you want to partner with someone that is familiar with these trends, that is familiar with what USCIS is looking for, and then being, again, very thoughtful in how you plan the petition and how you collect documentation from the foreign national and guide them through the process. And I think once someone secures an L1, it really positions them to, again, to have more options down the line, not only because they're here in the United States, but it leads into other immigrant options later down the road.
Thanks, Irma.
You're welcome. The next topic, or I should say next visa category that is common for life sciences companies, particularly those that have a entity abroad and it has a related US company, is the L1 intercompany transfer process. And essentially, you need to have a qualifying relationship between the US sponsoring company and a company that is located abroad, whether that is a parent subsidiary or other type of affiliation between those 2 organizations. And the 2 types of L1s are L1A and L1B as listed here. An L1A is reserved for an executive or a manager. So a manager can be a people manager in the traditional sense where you have direct reports, or it could be a functional manager where you oversee either a division, a unit, a department of an organization, and you are coming to the United States to serve in that particular role. And that is actually a really great option as well, because the L1 is a dual intent category, as Brian related in terms of the H-1B, and L1 is also a dual intent. And that L1A category allows for work authorization for up to 7 years. And for those that don't qualify for an L1A, we have the L1B, which is for individuals that possess specialized knowledge, whether that be proprietary tools that an organization uses, information that cannot be gained without working for the company for an extended period of time. And so if you have that knowledge and an organization wants to bring you from, for example, Switzerland, and their Switzerland office, and they want to bring you to the United States, you can demonstrate that you have a particular expertise within the company, and that's why they need you to come and work in the United States. And an L1B is provides you work authorization for up to 5 years. And another great benefit to the L1 that is very attractive to foreign nationals is the opportunity for their dependent spouses to actually obtain work authorization in the United States that's not tied to a specific employer. So it allows for individuals to bring their families with them, and also allows their spouse to work here in the United States. So that is, again, another option because of the dual intent component to the L1 that makes it quite attractive to employers when considering how to move employees from abroad and have them come to the United States to work here with their organization.
Thanks, Irma. That's really helpful information. So in 2021, it seems like a big theme is what people are calling the Great Resignation. People are leaving companies. The job market is really competitive, and we're in a very interesting time where employees kind of have the upper hand, and if you're not going to give them what they want, they will go find a job elsewhere. So what do you recommend? How do you, advise clients on best ways to both retain foreign national talent and to attract and recruit foreign national talent in a time like right now when things are just really, really competitive?
Absolutely. In terms of retaining talent, we'll start there for employees that you currently have. I think transparency into the immigration process for foreign nationals is extremely important. So allowing your foreign nationals to understand the policies that you have in place, and allowing them to understand the options that they have for permanent immigration options down the line. So for example, when employees are with a organization and they're in a particular status, they want to know, how long do I have to work here in order for me to be able to have green card sponsorship? That is a common question and a common concern that employees have when working with an organization. And of course, for folks entering the company, they also want to know, well, how quickly will you be able to sponsor me for a green card process? And depending on what the company's policy is, if you're a company that's taking the stance that you do not support green card sponsorship, that might actually deter individuals from wanting to join your organization. And for employees, if it's been a really long time, if you're waiting till the last 2 years of their immigration status to expire to actually start that process, which years ago was a common thing, foreign nationals are seeing that as also a deterrent and deciding, maybe I should make that transition to another employer that's willing to do this much sooner for me. Something else to consider, because in the life sciences, you do attract individuals that are in F1 student status and that are hoping to remain in the United States. If you, in the recruitment process, are clear about your policies in terms of even H-1B sponsorship, that will certainly give you a competitive edge over organizations that have not a set policy for sponsorship, and will actually invite candidates to want to work with you if they know that there's a possibility that they can have you sponsor them for an H-1B petition by putting them in that lottery that Brian discussed earlier in the presentation. So I think being very thoughtful with your immigration program, making it very transparent as to when foreign nationals should expect movement in their process, and also the commitment of whether or not you would sponsor these individuals, whether it is an H-1B or whether it's actual green card process, to allow that commitment to be known at the recruitment stage, because that is certainly a deciding factor as to whether someone would like to join your organization.
Thanks, Irma. And could you explain how soon can an employer sponsor someone for permanent residence? Is that dictated by the federal government, or is that something that's a company policy?
Great question. That is actually at the discretion of the company. So often the company will make a determination as to how long they want to wait to actually start that process. Some companies wait, again, to the last 2 years of the person's status to expire to allow for sufficient time to start the green card process. But what we're seeing more often now is companies that are implementing either a 6-month rule, so reviewing someone's performance with the company, and at the 6-month mark giving the green light to actually start the green card process. And so that would be a more common time frame, 6 months to 2 years. And then we're seeing other companies that are much more liberal with their immigration policies and are very in tune with what foreign nationals are looking for in terms of a organization. And so they may even decide that they want to have a day 1 green card sponsorship. So essentially, the moment that you are hired, you can immediately start working towards that green card process. So again, it's at the flexibility and at the discretion of the company, but it's important that whatever you do decide as an organization, that you remain consistent, that you remain transparent, because you don't want to invite claims of unfair treatment or that you're preferencing one group of employees over another. So it's something just to be mindful in terms of deciding what policy is best for your organization.
Thanks, great advice, very, very insightful. Thanks, Irma. Let's turn our focus to another very hot topic of 2021, and that's travel. So for me personally, it's been 2 years since I left the country, and I can't remember since I was a child any time where I've gone 2 years without traveling. So I'm sure I'm not the only one that is eager to travel internationally. And as most of you have probably heard in the news, the travel ban will end November 8th. This is very welcome news that we've been waiting for a really long time. And so I want to turn it over to Brian to talk just a little bit about this, about the end of the travel ban, and more specifically, what are the practical implications? Are we just going to see on November 8th and November 9th, everyone flooding into the US, or is it not going to be as easy as we think?
Yeah, thanks, Aaron. And I'm in the same boat. I last traveled internationally in January 2020, so I got a trip in there right before the pandemic really hit. But yeah, I'm itching to go too. And I think a lot of the foreign national population in the United States are, especially with holidays coming up, not seeing family in quite a long time, et cetera. So it is, like you said, it's fantastic news. It is great news that on Monday, so just a few days ago, earlier this week, it was officially announced through a presidential proclamation that the COVID regional travel bans, which was in place for 32 countries, impacting over 2 billion people, that's a lot of people that are impacted by these travel bans, will be rescinded as of November 8th. It is great news. It's a good first step, but we also need to temper that great news with the reality that even with fewer folks applying for visas because of the travel ban, consular appointment availability at U.S. consulates to get a visa stamp to be able to enter the United States, or even if you're here and you travel internationally for the holidays and your visa stamp has expired, you need a new one, you need to go to the U.S. consulate to get a new one. Visa stamping appointments right now are still scheduling for February, March 2022 for a lot of U.S. consulates all over the world. With the rescission of this travel ban, it's essentially going to open the floodgates and increase demand for visa appointments at U.S. consulates. And I think it's very, very likely that this sort of scheduling and availability is going to get worse in the near term before it gets better. So it is really good news that folks no longer will need what's called this national interest exception. They don't have to jump through, an extra set of hoops to get a visa stamp or to even enter the United States. But for folks that do need a visa stamp, that do need to attend a consular appointment, that don't already have a valid visa in their passport, travel is still going to be difficult. It doesn't change too much practically for them until U.S. consulates sort of return to a normal processing and normal availability. Now, a few things, and a lot of this is speculation right now in terms of, when will this improve and how will it improve? The fact that consular officers no longer have to adjudicate national interest exceptions as of the second week in November, does that free up some of the resources at consulates to then provide more visa appointments? Maybe a little bit, but that's not very likely to outpace the increase in demand that is likely to be seen. So again, this is great news, but from a practical perspective for a lot of folks, it does not change their ability to leave the United States and impact really how quickly they might be able to get back into the country. Now, there is the opportunity for requesting emergency visa appointments at consulates, but expectations there also need to be tempered from a practical perspective. Requesting an emergency appointment at the consulate is usually going to be reserved for medical emergencies, for deaths, for something extremely urgent. And a lot of consulates do have, urgent business need as, one criterion for where an emergency appointment might be available. But the reality is those requests are unlikely to be successful in sort of the day-to-day employment-based visa stamping process. So while that's there, expectations should be tempered in the availability of emergency appointments as well. So that's where things stand. Again, the proclamation is good news for fully vaccinated travelers. The requirement is that one must be fully vaccinated, meaning at least 14 days from whatever the last dose is of the COVID vaccination that they have obtained. So being fully vaccinated is a requirement. There has been and there still is a requirement to have a negative COVID test within 3 days of traveling to the United States for those who are fully vaccinated. And there are exceptions to being able to travel to the United States for those who are not vaccinated. For example, children under 18. Again, there is a sort of a national interest exception that I think is going to be granted sparingly, certainly more sparingly than the national interest exceptions for the previous travel ban. There are exceptions, but I think most folks should not count on that as being a likely possibility as we transition into sort of the post-travel ban world. So yeah, that's where things stand when it comes to consular availability and to traveling internationally. I think it's going to be a good amount of time, unfortunately, before consulates are able to get back to their regularly scheduled availability that you might have seen pre-March 2020.
Thanks, Brian. And you know, one thing that's always interesting, at least lately with the U.S. government, is they like to make these big announcements, but then they don't provide details until days or weeks later. So they announced the travel ban was over, and then no one really knew like what exactly that meant, and specifically which vaccines qualified, because I have clients that I've been trying, and we all been trying to coordinate for a while to get to the U.S. and we've had people go quarantine in other countries, and a lot of it depends on what each country recognizes as acceptable vaccinations. And so can you talk about what does the United States recognize? Which vaccines are acceptable? Because not all vaccines are created equally, it seems, and some are accepted and some are not.
Yeah, absolutely. And, you know, I think it's important to understand, one of the things I've discovered is different vaccines also have different brand names in different countries. You know, for example, I had a Brazilian foreign national that said, you know, is Corona, it's called CoronaVac. You know, I got a vaccination in Brazil very early on when vaccines were available. It's called CoronaVac. And I was like, well, you know, I'm looking at the list, and I'm going to talk about the list in a second. It actually is, and sort of the generic name is Sinovac. So you have to look beyond sort of the brand names too when we're looking at folks asking these questions as well. But for entry to the United States as a fully vaccinated individual, the vaccine that you've been given is going to have to be either authorized by the US FDA, the Food and Drug Administration, or by the World Health Organization. So certainly more vaccinations may be added to either one of those lists over time. But as of today, as of this morning, this is a list right here of the vaccinations that are permitted for travel to the US as a fully vaccinated individual. Now for a lot of the folks probably listening out there, you know, Pfizer, Moderna, we call it J&J, Johnson in Western Europe. A lot of the US used vaccines are also used, for example, in Western Europe, but it's less clear in other places. Like, for example, a lot of folks who might be in India, you know, is the vaccine that they have. Covishield is on the list. That is a common one that's in India. But there's going to be a lot of questions for folks as a lot more people become vaccinated across the globe. Am I eligible for travel to the US? And it's going to be a matter of checking those lists, which, you know, may be updated. You know, this information I have right here might be, you know, might be useless tomorrow, depending on how the lists are updated. But it does have to be FDA or WHO approved.
Thanks for providing clarity on that, Brian. We actually have a question from the audience asking specifically, are you aware of what the visa backlog situation is in Paris right now, and whether French nationals, French citizens can make appointments for their visa in embassies or consulates outside of France?
Really good question. So, and I actually, Fragomen being, you know, the large firm that we are with the global footprint that we have, we actually have teams, it's called FCP, the Fragomen Consular Practice, that work directly with consulates, that liaise with consulates all over the world. And I checked in with them this morning about Paris, a very, very timely question. It does depend on the visa type, but right now Paris is actually booking out into early February 2022 for most visa types. So I don't want to ruin anyone's holiday plans by giving you that information, but that's sort of the reality of the situation as it is right now. Really good question. You know, I'm a French citizen. Do I have to go to a US consulate in France to get a new visa stamp in my passport? And the answer is no. But again, there's something what's called a third country national. What that is essentially going to a US consulate in a country where you are not a citizen of. There is some limited availability for third country national visa processing in other countries. We've seen it be okay in a lot of Caribbean countries, depending on the visa type that someone is looking for. It is a possibility, but a lot of folks have sort of latched onto that concept, which has made this third country national processing become scarcer and scarcer at these consulates because their calendars are filling up, or because they have to, because of COVID, they have to reallocate resources to process those who are actually citizens of the country where the consulate is located. So it is possible. It requires maybe a little bit of forum shopping. It depends on the specific consulate. There's no blanket, every consulate allows you to just, enter their country and apply for a visa there if you're not a citizen from there. It depends on the specific consulate. The other thing to keep in mind is other countries that you might be traveling to also have COVID-related restrictions. So there are folks that go that, all right, I booked my appointment. I'm from France. I booked my appointment in X country, and I showed up there 3 days before my visa appointment, and it turns out I have to quarantine for 10 days before I can actually go to the consulate. I didn't realize that. So there's sort of a slew of other things to keep in mind if you are pursuing that option. But it is an option that does exist as sort of a maybe, and it's consulate specific. Their calendars sort of depend, and it takes taking a look around as you try to find a visa appointment.
Thanks, Brian. Another question that we have from the audience is, I have a consular appointment in December, but I'm worried about going back to France and being stuck because of receiving a DS 5535 for extreme vetting for H-1B holders in biotech. Can you speak to that and its odds of having this administrative processing?
Yeah, so, I think that administrative processing can be unpredictable. It is sort of the black hole that no one really has a ton of insight into. Certainly a possibility. It's going to be fact specific to your personal circumstances, to specifically what you do, what your role is, what your background is. So there's a lot of factors there that unfortunately can't comment on the probability specific to you because of those factors. Certainly feel free to reach out to the three of us. If you want to talk about it further offline, and we'd be happy to take a look at your background. But unfortunately, when it does come to administrative processing or security related concerns about administrative processing, there is almost no transparency from consulates. You could be in administrative processing for 5 days or 5 weeks, or frankly months. It's unfortunate, and unfortunately that may happen to you. But there's unpredictability in that, number one, and there's still unpredictability in that, even looking at your own personal circumstances and background. It may happen, it may not, and how long it takes to actually get processed can depend.
Thanks, Brian. And I'll just add that although it's completely unpredictable, the chances are pretty low. It's not that super common that you see this this extra vetting or this administrative processing, even for the biotech field. Maybe you see that more than you would for an accountant or a business analyst or something like that. But it's really not too common. And what makes it really frustrating is, like what Brian said, you just can't predict. And you don't find out until you're already out of the country. So if you want to go home for Christmas and you need to apply for the visa, well, you may be in for that surprise, and there's really just no way of knowing before you leave. So are there, for the audience, if there's any other questions, please feel free to type those in. We have about 10 minutes remaining. And while we wait for questions, I wanted to ask both Brian and Irma just generally on their thoughts. The last, I guess, 5.5 years have been interesting because we went from President Trump to President Biden. Obviously, they're on different political spectrums. And so things have been, you know, up and down, and there's been a lot of interesting things going on in immigration. I would love for either of you just to explain to the audience, you know, some of the changes that you've seen with the Biden administration, and what you believe we could be seeing in the next, you know, year or two ahead.
Sure, I can start and maybe pivot to Brian. I think it's an interesting question only because it's still new. The Biden administration is still quite new. However, we've seen some small changes that have been helpful, but also we've seen a continuity of the last administration, just because the last administration did have a significant impact on immigration, not only in on the travel front, but also in case processing. So we're still kind of dealing with the aftermath of having cases take much longer to be processed than in years past. We're seeing a lot more scrutiny, as I mentioned, on O1 cases and on general immigration cases across the board in terms of requests for evidences and having additional questions from USCIS officers. One positive thing that I do want to highlight, or I should say a few positive things I want to highlight, is this more open-minded approach to immigration and understanding that, you know, travel bans make it difficult for everyone. It's not just a foreign national issue, it's a global issue. And the importance of having fluidity in terms of individuals being able to have the opportunity to travel in and outside of the United States. So I'm hopeful that those restrictions, as we can see with the latest announcement, will make it easier for folks to have more mobility. Obviously, that processing delay that I mentioned has significantly impacted consulates. So I'm hopeful that over the next few months to the next year to 2 years, hopefully things kind of return back to what we knew as normal. And then another positive aspect is the Biden administration actually returned something called deference with cases. And so what that means is if you've already had an H-1B approval and you're within the same role and you're with the same company and there hasn't been any material changes, any significant change, then it's much more likely that your extension of your status, whether that be an H-1B extension, will get approved. And so deference allows the officer to look back and say, okay, they've been approved before, everything's relatively the same, let's go ahead and approve this. And that was eliminated during the Trump administration. And since Biden has actually returned that policy, we've actually seen higher approval ratings in terms of extending folks' status here in the United States. And that's something that, as small as one thing can make a significant impact. And I think foreign nationals are really starting to see the processing of those cases with much more favorable outcomes.
Yeah, and I think just to add to that, I think spot on, Irma. And the deference memo to me is the best possible thing they could have done as quickly as possible from the previous administration, because it does impact a large number of folks that are just extending status. A big issue that it can be hard to explain to an employer or to a foreign national employee is, well, I've been here on H-1B status with the exact same job, doing the exact same thing for the last 5 years, and now this time it's a problem. Nothing's changed. What the heck? And that used to be an issue that we would see in the prior administration, because I got rid of this deference. That's not to say that every single case doesn't receive a request for evidence or doesn't have an additional little bit of extra work that needs to go into it, but it's a big step in the right direction for the current administration. I think I'll add to that just a little bit by talking about sort of what the future might hold, because I think from a lot of people's perspectives, we do have these small time changes, but certainly like with any election year or any first year or first 100 days, there's always this push, okay, well, what's going to happen with immigration reform? What's going to change? What's going to be beneficial? in business immigration out there. And I think that, we're now, I think, eight years since the last time comprehensive immigration reform passed the House of Congress. Things move very quickly in the immigration world when it comes to legislation. And as many folks might know from the news, the Biden administration is focusing on infrastructure. They tried to maybe include immigration in bills and for procedural and parliamentarian purposes. They have not been able to do that. I'm not convinced that we're going to see anything in the near term in terms of legislation that is going to do anything to, for example, decrease backlogs for folks going through the permanent resident process who are born in India or born in China that have these significant years and years and years backlogs. I don't think we're going to see anything on that front. I think any changes that we do see are going to have to come from the existing structure of the INA, of the regulations. There might be some, new regulations promulgated, we'll see. But I think it's mostly going to come from a policy perspective. And we're seeing slowly in this first year, sort of a move back to, like Irma said, what we consider normal, the old normal. But other than that, we might not see any significant change in the near term.
Thanks, Brian. Very helpful, great insights by both of you. For everyone in the audience today, Brian put up on the screen our contact information. Please feel free to reach out to us if you or your colleagues have any questions. And like I said, we handle immigration to the United States, but we work with our partners and offices throughout the world if you're looking to transfer people internationally. With that being said, I would just like to thank everyone for giving us the opportunity to speak today. It was a pleasure, and we look forward to presenting to you all again in the future.
Thank you. Thank you to the three of you. I just want to say that a replay of this very informative webinar will be available online, posted on FACCNE's website and FACCNE's social media. Have a great day, everybody. Thank you.
Thank you. Good
Thank
day.
you.
Everyone. Bye-bye.
Thank you.